might think that once you set up a California living trust, you're fully protected and you don't need anything else. But the reality is many families still end up in probate court, not because they failed to plan, but because they assumed their living trust covered everything. In this video, we're unpacking the critical gaps your living trust leaves behind and why a pour-over will may be the most important document you didn't know you needed. I'm Ali Talai, estate planning and asset protection lawyer and founder of Talai Law Offices. Today, I will show you exactly what a will does that your trust cannot do, how a pour-over will capture assets you forgot to move into your trust, and what a real California estate plan should actually include. All right, so let's talk about a living trust. These are very powerful tools and they're used often, but like anything else, they have their limitations. Before I get to the limitation, I want to talk to you about why we use them and where they're very useful. Number one reason you see a revocable living trust used is for the reason that they're a fantastic tool to avoid probate. Probate is a process that you don't want your family to go through unless you don't like your family or your kids. But I'm assuming if you're watching this video, you probably do care and you want to make sure you put something together that is the appropriate estate plan. Probate, let's go to that. Probate is a court proceeding that sometimes families have to go through when a parent passes away and that parent had assets owned under his name or her name individually. Probate allows the transfer to the beneficiaries and also gives the creditor, if there are any creditors, to be able to collect whatever is owed to them before the assets gets passed to the beneficiaries. The problem with probate is that it costs a lot of money to go to probate in most cases. It's not a private proceeding, it's public. Anybody could go to court and find out, what's included in the estate, who's getting it, where the properties are. And then it is a very long proceeding. It could take over a year and a half to have the entire thing from the beginning to the end sort of completed. So by incorporating a living trust in your estate plan, you have the ability to be able to avoid probate for your loved ones and family at the time that you've passed away. And so that's one of the main reasons these things are used. In a revocable living trust, if drafted properly, you could also do planning to avoid the needed probate proceedings if something happens and you don't have mental capacity. So mental incapacity can be something else that a revocable living trust can be used for. And then lastly, by having a revocable living trust, you can still have your wishes indicated in there. They are just like a will, so you will indicate in your trust that who you want to receive the assets, what percentage they'll get it, when they will get it. All these things are also indicated within the trust. However, they're kept private. In a trust setting, the actual trust, if everything has been done correctly, does not get filed with the probate court so that the document stays private and nobody else beside the immediate family and the trustee of the trust won't know what's included in the trust. And again, so it provides a great deal of privacy as well. All right, so let's talk about what your revocable living trust cannot do. So let's talk about the limitation that a revocable living trust has. A revocable living trust, it doesn't matter how great this trust is. It will only control the asset that you have placed into the trust or somehow connected it to the trust. So if you forget to transfer your assets into the trust, or if, let's say, you purchase a new property and you forget to transfer and retitle the property to the name of the trust and you pass away, this revocable living trust, if that's the only thing that you have and that trust was drafted pretty basic, it will not control the assets that are outside of the trust, that they were never owned by the trust. And this is one of the main reasons that we want to make sure that we also include a pour-over will when you're doing your revocable trust estate planning documents. So usually when you're setting up your revocable living trust, in addition to the revocable living trust, you want to make sure that you also have a pour-over will in place and executed at the same time you're doing your revocable living trust. The reason that this pour over will becomes so important is that this document, even though it's a will, the main reason it's being incorporated and it's being used in your estate plan is intended to act as a backup plan and sort of cover certain things that you may forget to do or you don't get the chance to do it. So you set up the revocable living trust. The pour over will is here on the side. What is intended to do is that if something happens to you and you forget to transfer a particular property into the trust, this pour over will pours whatever that is outside of your revocable living trust into your revocable living trust. And so it acts as a mechanism to incorporate other assets that you have that for whatever reason you forgot to transfer or connect into the trust. By having the pour over will, now we could feel very comfortable to make sure all the assets that we have will be connected to the trust, and now the distributions and the way we wanted things to be divided and given to particular individuals could actually take place. One thing I want to mention to you as far as the pour over will, even though it pours over into the trust the assets that are outside of it, it doesn't do it automatically. It still will require, in most cases, a court proceeding and a court order that says such and such property or such and such bank account is now transferred into the trust. And even though that would not require a full probate process, we're still going to the probate court. There's still expenses to get that particular order, and it'll still take some time. Again, it won't be a year and a half. It might be just 2 or 3 months, which compared to a year and a half is a shorter period. But the reality of it is that what you want to do, you want to make sure you title your assets and you connect your assets to your trust and not rely on the pour over will. Because again, like I mentioned, it doesn't transfer the assets automatically. It'll still require some work from the beneficiaries, and there'll still be some expenses associated with it. So the goal is that you make sure you title and fund the trust properly while you're alive, but you still want to make sure you have this pour over will with your estate planning documents. So if something happens and you forgot to do that, you know that your estate planning and your wishes and your wants will actually be carried out over all your assets. Another really important factor when we're setting up a pour over will for a client who has children that are under the age of 18 is that the client wants to make sure that there are legal guardians named within their estate plan. And in order to name legal guardians, they have to be named in a will. You cannot name legal guardians in California inside of your trust. So even though we're doing a revocable living trust to avoid probate, if we want to make sure we have a comprehensive plan that deals with legal guardians for children, you got to make sure you name the legal guardian in your will or pour over will, so that if unfortunately something happens and the children are under the age of 18, that document, the pour over will, can be used to have the right individual appointed as the legal guardian for your children. All right, so lastly, let's just go over what documents you are going to need so that we could say your estate plan is complete, is comprehensive, and those documents are, number one, you got to have a revocable living trust in your estate planning documents. Usually that's one of the first documents that you'll see in estate planning documents. However, having the trust is really important. Make sure you sign it. These documents, revocable living trust in California, do not need to be witnessed or anything like that. They don't really even need to be notarized, but I would still suggest that you have it notarized. You got to make sure you fund your trust. We talked about this a little bit already. You got to make sure that if you have assets, that you have connected them to this trust if they're supposed to be connected to the trust. For example, if you have a home, you got to make sure you retitle the property into the name of the trust. If you have shares in a corporation, membership interest in an LLC, partnership interest in a partnership, it cannot be under your personal name. If you have a trust and you want it to go and be divided based on the trust terms, you got to make sure you assign those interests to the trust. So having the trust is step one, but funding it it becomes step 2 and really as important as a step 1. The other document you want to make sure you have is a pour-over will. Pour-over wills do have to be witnessed, 2 witnesses in California, and obviously you need to sign them. Again, they become essential and very important to be able to act as a mechanism to cover whatever that was left outside the trust. If for some reason you forgot to transfer a particular assets into the trust, this document allows to pour over and transfer whatever that is outside the trust into the trust. The other documents that you got to make sure you have in your estate plan is financial durable power of attorney. That document becomes essential, very important to make sure it's in place so that if something happens and you don't have mental capacity, whoever is the agent you have named, that person will have the authority to be able to contact the bank and get whatever that needs to be sort of taken care of to take care of those things. The next document that you got to make sure you have is a California Advanced Healthcare Directive, HIPAA authorization, certificate of the trust, and also an assignment of personal property into your trust. Now that you understand why even the best living trust needs a will to back it up, let's talk about the next major risk most Californians overlook: lawsuits against rental property owners. In my next video, I will show you how to protect your rental properties and everything else you own from tenant claims, accidents, and lawsuits. You will learn the structure smart investors are using to keep their names off title, shield their personal assets, and sleep better at night. If you own real estate in California, you cannot afford to miss this. Click over now and learn how to build real protection into your portfolio.